Hello, everyone. This is Angie from TechServe Alliance. Welcome to today's webinar, Protecting One of Your Company's Main Assets, Your Team and Talent. If there are any questions you would like to ask the speaker, please type them in the Q&A box, which can be found at the bottom of the screen. We are also recording today's presentation, which will be available on the TechServe Alliance website and will be distributed to in follow-up emails. Now, I'd like to introduce you to Marty Borosko, Practice Group Leader of Becker LLC.
Well, thank you, Angie. Hello, TechServe Alliance, and hello to all the TechServe Alliance members joining us today. For those of you who don't know me, Marty Borosko. I am the Practice Group Leader at Becker. Becker is a boutique law firm with offices in New York, California, Pennsylvania, and New Jersey. And we really focus our practice in a couple of discrete industries where we have real expertise and experience. Our largest practice group in the firm is, in fact, our staffing industry practice group. We have represented over 100 brands across the country. And today, joining me is my partner, Chris Leddy. Hello, Chris.
Hey, Marty. Good afternoon.
So we have an incredibly critical topic today. As Angie said, protecting one of your main assets, which is your team and your talent. And as we talk about protecting your team and talent, we're also going to be in a lot of ways talking about protecting one of your other key assets, and that is your brand and your goodwill. They really overlap in many instances. So it's a very important topic because, as we know, for staffing firms, their value is in those two assets. It's in their talent and it's in their brand and their goodwill. We don't have products. It's not Coca-Cola. We don't have a secret formula. It's not Intel. We don't have a patent on a chip. It is really the people and the goodwill and the brand that are what constitute the value that a staffing firm has. And why the topic's so important today is because of the marketplace and the economy that we see ourselves operating in today. So we've got two factors that make this topic extremely timely. One is current valuations in the marketplace. You know, we are at or near all-time highs in industry valuations, and in particular, obviously, IT staffing firm industry valuations, which means that all of you have built what today stands as an incredibly valuable asset. And what we're going to be talking about today is going to help you protect that valuable asset. And then you couple that, of course, with the fact that we're just in an unprecedented talent shortage. We know it obviously infects your ability to fill orders and place your contingent workers, but just as much it impacts and affects your ability to maintain and recruit and keep your talent. So facing these, kind of two particular circumstances that we have, it really makes this topic, critical to everyone on this call today. So, we're really going to focus in on one particular area of protecting your talent and your brand. Most successful staffing firms have, a comprehensive plan in place and policies and for protecting their brand, their goodwill, and their talent. But Chris and I, because of obviously only having an hour, are really going to focus in on a particular area. And that's really the role of restrictive covenants in people protection and brand protection. Chris, maybe you could start by explaining to everyone exactly what are restrictive covenants.
Yep, thank you, Marty. So restrictive covenants generally are going to be your confidentiality agreements, your non-solicitations, right? You're not allowing your employees to go after your clients, your other employees, kind of anti-rating, if you will, anti-poaching. Now you also have non-competes, which basically take them out of your marketplace for a certain geographic area for a certain amount of time. Then you also have, which is inherent in every contract, really it's a duty of loyalty, right? So a duty of loyalty, it's not a restrictive covenant per se. It's not going to be in an agreement. It should be mentioned in your employment agreement, but it's not going to be spelled out like a non-compete or non-solicitation is. What that means is while the employee is working for you, they cannot do something to harm you, to take away from your business, right? So The restricted covenants are during and post-employment. The duty of loyalty is only while they're employed by you. So they can't start siphoning off clients, sending them to their new employer. If they have a plan to leave, they can't start taking your confidential information. They have to be working for your benefit while they're employed by you. And just as a general rule, restricted covenants that are entered into are enforceable as long as they're reasonable in time, area, and they're necessary to protect your interest. They're not harmful to the general public, which they generally are not, and not unreasonably burdensome to the employee, which they generally are, but I don't think that factor really plays a big part in most courts' decisions, or at least doesn't play the factor that you think it would play. So while most states will enforce RCAs, they're going to give, or restricted covenants, they're going to give the employee every reasonable doubt to not enforce it, right? So that's why when you're crafting these restricted covenant agreements, they should be very narrowly tailored to what you actually do, right? If you start broadening it, it's either going to be struck down, it's going to be reformed, and you're not going to get the benefit that you think you're getting. Also, too, you have to be cognizant of the time periods, right? Generally 1 to 2 years. 2 years is usually the max for employment purposes. Obviously, if you're going to sell, as Marty can tell you, you can get up to 5 years if you're on an M&A deal with prior owners. But for employment purposes, really you have to stay at the 1 year mark or the 2 year mark, depending on what state you are in.
Thanks, Chris. I'd like to start off maybe, Chris, because to me, this is the most important of the restrictive covenants. And I also think it's maybe the most overlooked, or maybe it's not overlooked. I don't think that staffing firms always fully implement programs to really match up and secure these restrictive covenants. And that's kind of the confidentiality and trade secret covenants that are so important for staffing firms to have with all of their personnel. And the reason I think it's most important is quite simple. These provisions really protect both the brand and the goodwill, right? The trade secrets are more than just the people, they're the brand and the goodwill. And they are preventive of what I would call naughty behavior by your employees while they're either with you or have left you. So, that's why I really think that it's important. And you mentioned that, my background and where I focus my time in the staffing industry is more on what I would call the strategic side, and in particular focusing on mergers and acquisitions and confidentiality provisions, trade secret protection is really critical when you get towards a sale transaction. Buyers care. I'm not even gonna say care. Buyers are almost obsessed with scrutinizing what staffing firms have done to protect their trade secrets. So to me, this is a critical topic. And I think what's interesting, Chris, obviously, is you have a little bit different perspective. I come from kind of the M&A perspective. You, as a former in-house counsel, and then shifting over to Becker, your role is more in the everyday policy drafting, policy implementation, policy enforcement. So I think we'll kind of bring two different perspectives to this. But what I would say to the audience, especially as Chris talks about what the law is, the policy drafting, talks about policy implementation and policy enforcement, really focus on three things when it comes to confidentiality and trade secrets. Okay, and I'm going to interject at times about this. You want to focus on access. Okay, it's really important how you control access to this information. The second thing you want to focus on is what I call acknowledgement. Okay, you want to have your employees acknowledge the importance of this material and that you've shared it with them, and that they aren't to share it with other folks. And then the last thing is control. You really want to be able to control this material, both its dissemination and the devices where this material rests. So maybe, Chris, maybe you can step back and explain, what type of confidential information should staffing firms be looking to protect? And what exactly is a trade secret? I mean, it's a legal term. Maybe you can explain that, because I think that's important context.
Sure. So as you said, Marty, there's a difference between confidential information and trade secrets, right? Trade secrets are going to be a much higher standard, much more protection than even confidential information, right? Because confidential information it's more personal to the company, whereas a trade secret, everybody knows or should know it's a trade secret, right? Like the Coca-Cola formula, right? The Colonel's special recipe, those are trade secrets that they're beyond confidential information, right? So when we're looking to draft confidentiality agreements, it really consists of your intellectual property information pertaining to research and development, your services, your designs, your sales and marketing, software programs, customer data, your candidate data, employee data, your business plans, projections, everything that's not readily available to the public and that you've dedicated time and effort to create should be included in confidential information, right? And along those lines, when you're drafting that agreement, you want to make sure that you're making the employee know that that information can only be used to further the company's business interests, right? For no other reason. It cannot be disclosed for any other reason. Obviously, there's going to be exceptions for court orders. If they're required to disclose it by a court order, they're going to have to disclose it, but they should give you an opportunity to get a protective order or to, if it's a subpoena, to quash that subpoena so it doesn't have to be disclosed. If you're unsuccessful in getting a protective order or quashing it, then that employee should only be giving up that information that is requested, nothing more, nothing less, right? Then obviously they can disclose information once it's no longer confidential, right? Once it's readily available to the public through no fault of theirs, right? Through no act or omission of theirs, then it's no longer confidential information, so they can go ahead and share that. As Mark said, this is probably one of the most important things in the employment relationship to have in, probably even more so than non-competes and non-solicitations, to protect your information, because confidentiality agreements are enforced in all 50 states, right? And I guess District of Columbia too. So even in states like California, where they say that you really cannot have non-solicitations or non-competes, you are permitted to have confidentiality, and you could sometimes tie non-solicitations to confidentiality. But I want you to keep in mind though, just because you deem information to be confidential doesn't necessarily make it so, right? For instance, the recent case that came out said that KPI reports, which included things such as client names, how much each client was billed, what the markups were, how the salespeople were rated, any pending proposals, new sales information, were confidential information. On the other hand, the court said, if that information is readily available, right? If I can go on LinkedIn and find that candidate, or I can find these companies putting this information out for bid, that's obviously not going to be confidential. So you keep that in mind. Just because you believe it to be confidential doesn't necessarily make it so. If I can do a simple Google search or spend a little bit of effort to find out what you consider to be confidential information. As far as trade secrets, a trade secret is defined as any formula, pattern, device, or compilation of information which is used in one's business and which gives the owner an opportunity to obtain advantage over competitors who know it, who do not know it, or who do not use it, right? So to get a claim for a trade secret violation, you have to show that you actually possessed it, right? And that there was a breach of an agreement, some kind of confidentiality, or the information was obtained through illegal means or improper means, right? Somebody stole somebody's password, went on your system, took that information. Obviously, that's going to be a violation, even outside of misappropriation of trade secrets. It could be criminal. But that's the type of standard you have to get to when you're looking at trade secrets. And then,
go ahead, Mark. No, go ahead.
So I just want to give you guys a couple quick factors that courts look at when determining what trade secrets are, and show you what kind of heightened standard that you're looking at here. Is the information known outside the business, which is going to go to confidentiality as well. The extent to which it is known by employees across the business, right? So if you have somebody who's maybe in a clerical position through C-level who has access to that information, it's not going to be a trade secret, right? It has to be within a select group of people that know about the information, who have to know about the information, and who, what Marty said, have access to it. Again, access is the key in that part. That flows into the next point, is the extent by what security measures you're taking to protect that information, right? Again, it's on the shared file, not going to be. The value of that information and the amount of time and money that you spent to develop that information, right? So if you pay somebody to compile some reports or to find clients for you, give you a client list, obviously not going to be a trade secret, not even going to be confidential information. And then that goes to the last one, is the difficulty with which the information could be properly acquired or duplicated by others, right? So if you put 3 years into developing your own list, that's different. If you're buying a list, not going to be. So the problem with trade secrets, especially in the staffing industry, is that courts have stated that clients in the staffing industry generally will not keep their secrets or their needs a secret, right? They're going to share their needs with you. They're going to share their needs with other staffing firms, and sometimes they're going to share your pricing or other staffing firms' pricings with you, right? So that takes it out of the whole equation, takes it out confidentiality as well. Again, we went through what efforts you took to protect that information. Pricing is generally not going to be a trade secret or confidential information. Markups to ensure profitability is not going to fall into that, right? Unless you have some kind of complex pricing or trading algorithm or proprietary formula that you use to come up with it. That proprietary formula will be that, and the end pricing, as long as you can't reverse engineer, will likely not be. Finally, I think it goes without saying, finding candidates on social networking sites, job sites, word of mouth referrals, job fairs, general recruitment efforts are not going to be confidential information or trade secrets, right? You or I can sign up for LinkedIn Recruiter. We can go on LinkedIn. We can search for people looking for jobs, post jobs. It's available to everyone. So when you're drafting these, and when we draft these, we generally try to include everything, right? And we'll put what's called a severability clause, reformation clause in these contracts, so a court can say, okay, yeah, that's not confidential information, but the rest is. So we try to be purposely over-inclusive because we want to try to give you as much protection as possible, and at least have that argument to be made that it is confidential information. So when you're drafting these, keep that in mind.
So we have our first question. So why don't we answer that? Chris, I think it's largely to you, but I'll talk a little bit. The question is, can employees, specifically recruiters, moonlight after hours recruiting for their friends who are not clients of our firm? A pretty complex question that's fact specific. Obviously depends on if there's any employment agreement or company policy in place, and whether that would allow that. But I think it also, Chris, where I'd like you to go, talks about the duty of loyalty. Yep. Obviously you might need more facts, but talk about how the duty of loyalty might kick in there.
Yeah, so if they're moonlighting and they're taking away business otherwise from you, right? Then yeah, they would be breaching that inherent duty of loyalty that's implied in every employment relationship, right? They have to do what's in your best interest. They cannot do it for a third party. And if you're worried about moonlighting, typically you'll put a non-moonlighting clause in your contract too. Now, problem with that, some courts do not like the non-moonlighting clauses, especially for non-exempt employees. For exempt employees, I don't think it's an issue. Whether your recruiters are exempt or not is a whole nother issue, and we could do a whole nother webinar on that. So I think more often than not, if you have exempt recruiters, you can put that anti-moonlighting clause in there.
And I think it's a good example. These are the kind of nuanced questions that obviously this topic, as I said at the outset, is incredibly broad, and folks need to have a comprehensive policies in place. This is a nuanced question that your policy should address, right? Moonlighting should be addressed in your policies and your agreements and your offer letters, and where you formulate what your position is and whether or not folks should be doing it. I just wanted to pick up, Chris, on and just bring the audience back to what I was talking about: access, acknowledgement, and control. And you could hear in Chris's recitation about how courts view confidentiality provisions, the definition of trade secrets. The thing that really resonated from that, and this is coming back to my perspective of the end of the line in a transaction where somebody's going to sell their business. This is what the buyer is focused on. And they're going to look at, and what you need to have is a program of access, right? It's very important that you look, once you design your program, what is your confidential information? What's the secret sauce? What are your trade secrets, right? They need to be identified. You need to understand what they are. And then you really have to think about who should have access to that information, because everyone should not. And the more important the information is, your client list, right? Maybe you do have a unique pricing schedule. I mean, I kind of, a buyer always wants to know that you've taken some steps to protect your margins and your pricing. Now, whether that actually holds up in court, it's questionable. It depends on what it is. But those type of things, you need to think about who should have access to that information. Your computer systems, your policies need to reflect that and need to limit it. The people who have access need to acknowledge that they are special people and that not everyone is getting access to that information, and that they understand the importance of that information and the critical role that it plays in protecting the company. So, make sure, everyone, that you've got a lot of thought into who gets access within your systems, a lot of thought as to what your confidential information and your trade secrets are, and that you've spent the time to design a system that has limited access to only those people who need it, and a system that has the folks acknowledge that they're part of the privileged class that has access to this and how important it is. Because you heard in Chris's recitation, what importance that has. And then I want to go to another subject, which is what I call the control factor, right, Chris? So there's two forms of control. It's access, who can get into it. But then we have the products, right? We have cell phones, we have laptops, right? Especially working remote, right? We have, a lot of folks aren't in the office where the company owns all of the equipment, right? So, control over those devices plays an important role in this as well. I personally think the best practice is for the company to buy all of the products and own them. I think it's the most protective way to do that. Buy the cell phone. If at the end of somebody's employee term, you want them to be able to buy it back from you for convenience sake after you've taken off all the information, done everything you need to do to scrub it, you can do that. But I'm a big proponent of companies owning that material. Maybe you can talk about a little bit of that, Chris, the distinction of what happens when the company owns these devices versus the employee, and maybe some policies that folks should think about having in place along those lines.
Yep. So I agree with you, Marty. The company owning it, right? It's company property. You have the right to access it. You're not going to have the right to access personal items are there. So personally protected items. You cannot request certain passwords that are personal to them. However, if you have a policy in place that says that they can only use their equipment for work purposes, it really shouldn't come into play. Part of that policy should also include that they have no expectation of privacy in anything they do on these devices, right? That you are going to monitor, you're going to gain access to it, you own it, and at the end of the day, they have to return it all to you, right? They can't disable any software on it, they can't disable any tracking what have you. Same thing for cell phones, right? So a lot of times we know recruiters, salespeople are texting now. Those are company records, right? We need those records, and if you ever end up getting sued, those are records that are needed, right? They should not be deleted without your permission. There should be a deletion schedule, destruction schedule that you have in place as well that has to be followed. As far as working remotely, you need to have a remote.
Can I just jump in right now?
Yeah.
Just bringing my perspective. Buyers ask that question in diligence every deal, right? That exact question. And they ask, what steps are you taking with respect to that type of information? So it's not only important for protecting you today, but it's important for protecting you, when you go to sell your company. Sorry, Chris.
No, it's a great point, Marty. And I was just going to add on to that is make sure you have a remote policy, right? If your employees are working remote, make sure that you have some kind of policy in place that says only they can access the computer, only they can use the computer. They cannot supply their passwords. They cannot leave information out and about where other people can see it, whether it's their family, friends who are over. The remote environment really, which is again a whole nother topic for another day, has created, obviously new access to otherwise people you may not have employed before, but it's created new problems too. So these are all issues that you have to really think through that you may not have thought of when you hired these people.
Thanks, Chris. We have another question, and this kind of relates back to, what categories of information you can protect, Chris. And the question is about LinkedIn contacts. Can they be considered confidential information and subject to a confidentiality restriction?
So confidential, the LinkedIn contacts for, I'm assuming for salespeople, recruiters, it's probably not confidential information if the person, so if you're using, the premium LinkedIn and you're seeing all these people who are available and you're compiling a list, that list, again, it's out there, right? You're just pulling that information. But what you can do is, you're talking, if they're talking to candidates, clients, that goes into the non-solicitation, possibly the non-compete, which we'll get into in a little bit. So it's outside, it could be outside of the confidentiality. I think you could make arguments that it is confidential information, that you've dedicated time, effort, expense to develop that. Whether it's a winning argument really is going to depend on what court you're before. So it's, again, all these are going to be really fact sensitive to what they had access to and what you did to safeguard it, like we've been talking about.
Thanks, Chris. We could talk some more about confidentiality and trade secrets, but I want to jump to one of the other important restrictive covenant conversations that I know you and I want to have today, and that's non-competes. The question is, are non-competes dead? Are they not dead? Maybe you could talk about the state of the law with respect to non-competes. And we can talk about proper use of non-competes for folks in the industry.
Yeah, so I think they're not dead; they're dying. Right? They're going away, and I think non-competes too, if you're just using them across the board, probably shouldn't be used across the board, right? Non-competes should be reserved for certain people, certain high-performing people in your company, right? Consultants probably should not have a non-compete, right? Non-solicitation will protect you, or should protect you enough, as long as it's properly crafted, from a consultant. And a lot of courts have said that. They've actually come out and said you're more than protected enough by a non-solicitation. You don't need a non-compete, right? You don't need to pull them out of that industry for a year or two. In fact, there's actually some statutes like in Massachusetts that actually say that if a non-solicitation will give you the protection you need here, we're not going to force a non-compete. So, and that's why it's really, really important when you're drafting non-competes to know what state you're in, right? Because every state law, or every state's going to be a little bit different. Some states have actually codified, so actually put in statutes surrounding non-competes. And then B, crafting it to your business, right? What do you do? What does that person do for you? It really has to be personal to you and that person if you want a non-compete to stand up. Courts do not like non-competes. They're going to try not to enforce non-competes for the most part. And you're going to have certain courts, I would say, the redder the state, more likely you are to enforce a non-compete. The bluer the state, you know, it's kind of a ice and hell type deal. So when you're drafting these, look at what do you do? Do you do executive recruiting? Do you do contract staffing? Are you doing direct hire, permanent staffing, right? If you're doing, define that, define what your business is and narrow it to what industries you serve, right? Do you serve banking, government, healthcare, IT, you know, executive management, operations, engineering, light industrial? Say that. Define what your business is so you can define what your competitors are, right? Because that's the whole purpose, right? Who is your competition? If you're not setting that forth clearly and you're making it overly broad and saying the staffing industry as a whole, it's not gonna hold up. You also have to think about things like the geographic area of it. I mean, is the whole United States gonna ever hold up? No. I shouldn't say it. Sometimes it will. I mean, there's a, I guess, a famous case from 20, 30 years ago now at this point, where a gentleman was, which isn't staffing related, but I think it drives on the point where he did all the slot machine programming, right? And he was one of the only ones who knew how to do the slot machines. At the time, it was only AC and Las Vegas that had slot machines. So they said he could not compete in those two markets. Well, effectively, they took him out of the entire market, and the court upheld it and said, yeah, it will apply. So again, keep it narrow, keep it to what the person does, right? Obviously, a recruiter is going to be different than a consultant. Make sure you narrowly craft it for them.
And I think, again, sticking with our two different themes, you know, taking the non-competes and thinking it through, right? Going back to what I've been talking about is mapping. This all needs to be mapped, right? Access to information mapped, right? Who do you have non-competes mapped? This should all be part of a comprehensive program. And so you're making very important select decisions about who executes a non-compete and what they say, right? They might be slightly different for a salesperson, a recruiter, you know, somebody in your financial group, right? This might be separate, differently worded and differently structured non-competes. So again, it goes back to the whole mapping everything out and making sure that you've thought through a comprehensive strategy of how you're protecting your talent and protecting your brand. You know, something kind of, I don't want to call it new. I think maybe more emphasis on it, maybe slightly new. Chris, I'd like to ask you about. It's salary thresholds and waiting periods. I think there's a lot more conversation about those today. Can you explain, you know, what they are and why they're important?
Yeah, so a lot of states are passing salary thresholds and, like you said, waiting periods. One of those states is Illinois, right? They just put out, not just put out, it's been about a year now, that you cannot have a non-competition clause with somebody who's making $75,000 or less, and you can't have a non-solicitation clause with somebody who's making $45,000 a year or less. That's going to increase gradually every 5 years until 2037, when it caps out at 90,000 and 52,500. The reason that's happening is they don't want to restrict the low wage earners, right? So it's a public policy override. I think it's coming if it's not in your state yet. I think more and more states are pushing towards that. It's better than the total bans of non-competes that some states have. But you have to be cognizant of that, because if it changes, it could be retroactive. Most of the time, the laws aren't going to be retroactive, but some are. Also, you have to look at the waiting period too. Illinois has a 2-year waiting period before you could actually enforce a post post-employment non-compete. You're also having states pass laws that say that you have to give the person opportunity and notice of non-compete before having them sign it, right? So some require 10 to 14 days so they can review it with an attorney, knowing their rights, whether they should sign it or not. Then you have people who, if they're fired or laid off, without cause, that they're no longer enforceable. So it really, I can't stress enough, it varies state by state. And the state that you're looking at is most of the time more than likely going to be where the person works and the state where they physically perform the majority of their activities, right? So if they're working at home, they're remote, you're in Arizona, you're somebody in Massachusetts law is most likely going to apply there. So that's why you have to be familiar with Massachusetts law, even though you're an Arizona corporation, right? You may not do any business in Massachusetts other than have that employee there, but Massachusetts law is going to apply there, and it's vastly different than Arizona law is.
And I think there's an important thing you brought up there, Chris, and that is the correlation between compensation and effectiveness and enforceability of non-competes, because there is a real direct correlation, not just obviously now in these salary threshold laws that we see, but in court examination of this as well. And so, in designing your program, be aware of that, and look at compensation as a factor in constructing your non-competes, and look for opportunities where you are giving consideration or compensation, and where that may give you an opportunity to get a little bit more aggressive with a non-compete, or, as we're going to talk about, a non-solicit. So one type of a situation is a lot of our clients, and I spend a lot of time with our clients on compensation plans, especially long-term incentive compensation plans, such as SARS plans and phantom stock plans, change of control bonuses. In those type of contexts, you're often giving an employee what could be considered an extraordinary award, and you may have an opportunity to get a little more aggressive with your non-compete. So pay attention in designing your strategy to compensation and how that may impact your ability to tighten or get a little more aggressive with a non-compete. Now this is, I think, maybe our last topic on non-competes, Chris. Penalties. I'm sure most people on this webinar understand that in some states now they're imposing penalties on companies who include non-competes in the contracts. To explain that and what states that is for the audience.
Yeah, so you're right, Marty. Some states are actually posing criminal penalties on owners, people who put non-competes in place when they're not allowed to, right? So an example is going to be Colorado. Colorado says that non-competes are void because they restrict trade unless they fall within certain exceptions. And if they don't fall within those certain exceptions, and you have someone sign one, as of this past March, so about a month and a half ago, a person who violates that statute commits a class 2 misdemeanor punishable by up to 120 days in jail and or a fine of $750, right? Obviously you prefer the fine there. But the fact that they put jail time in there is, it speaks volumes, right? They're really trying to do away with non-competes except in limited circumstances. That's why we initially started this with non-competes are dying, right? They're dying because the risk personally just isn't worth it in some states. So that's just another really big reason to stay away from non-competes. The Department of Justice recently came out too and said, if you have a non-solicitation, you don't need a non-compete. On top of that, it may be a violation of the Sherman law, which is an antitrust law. The DOJ hasn't been totally successful in that argument yet, but it is something to watch because in the future they very well could be. So at a federal level, you could knock out non-competes.
And I think that raises the last important topic on this that I want to discuss. One mistake we see our clients make all the time is, they really have the right intention to put together a comprehensive plan, to put together a very well thought through non-compete or other non-solicitation, but they don't update, right? I mean, the law on non-competes in particular is evolving constantly. So it's really important that you are re-examining, the programs you're putting in place here and the covenants that you're putting in place here, because the law is constantly shifting in this area. So Chris, I think, gave real good advice there to folks who are on this webinar, is that you have to look at these provisions, you have to look at these restrictive covenants, and you have to look at them, every year or two to make sure that what you have still works under what could be a shifted landscape. So let's hit the third of these type of covenants, Chris, and that is the non-solicitation. And I think you stole a lot of my thunder of what I have to say about these, and that is, next to the confidentiality provisions, these to me are the most important now, because many courts, as you've been saying, look to these as the real protection that a company has, right? Versus it used to be the non-compete. Now it's, hey, if you've got non-solicitations, they're your protection. So that's really the shift that's taking place. And if you take a pause and you think about it, well, what does that mean? Well, what that means is that these are incredibly important provisions now, and you better do a good job putting them together correctly, because this is going to be, with your confidentiality provision, this is going to be your protection or not. So explain, maybe, take a step back. What are non-solicitation provisions? There's different types. What do they look like? Maybe give the audience a little overview.
Yeah, so I think we start, what is a solicitation, right? And a federal court recently provided some guidance on that, and the court said that it falls anywhere ranging from active attempts to attempts without prompting to contact either an employee, a former employee, a former client, and that anything in between would be a solicitation, right? That's why it's really important to define what a solicitation is. Typically, you're going to have language that any communication, whether it's directly or indirectly to hire, recruit, solicit, or to attempt to do any of those, whether it's with your clients, your contractors, your employees, your suppliers, your vendors, anybody that you put dedicated time and money to develop that relationship that is beneficial to you, adds value to your company, is something that you're going to want to protect. You tying that also to confidential information, because they would not otherwise know them, right? But you have to make sure that you define what your clients are, right? Is your client somebody that you're currently working with, or is it a former client within the past 12 months? Is it a prospective client? Is it a former employee who left within 6 months? Is it only current employees? All things that you have to constantly think about, and you should define in the agreement. Further, it has to be limited. It really should only be limited to those people that former employee had contact with, right? Or received confidential information about, or whom their subordinates had contact with, right? Contacting and accessing, how do I know what your clients are or who your clients are, right? And that's a common pushback that you're going to get from defense attorneys. And then they'll say, fine, we'll consider your non-solicitation. Let's try to resolve this. Give me your client list. And you're going to laugh at them and say, no, there's no way I'm giving you my client list, right? Because after the non-solicitation is up, you're going to go ahead and solicit them. So definitely do not have blanket provisions. Draft it narrowly. Again, the more narrow you draft it, the more likely it is going to be enforceable.
There's always a little bit of a debate or misunderstanding between what I would call on the employee solicitation clauses, what is a non-solicit versus a not hire, right? Can you explain the difference between a non-solicit and not hire, if one's more enforceable than the other, just real quick?
Yeah, so a non-solicit is basically reaching out, attempting to gain to hire them, right? So it's different than not hiring, right? It's the not hiring is just that you can't hire them, but it doesn't stop you from reaching out, developing that relationship, maybe cultivating that relationship at the non-hire period. Whereas non-solicitation, again, you might have a third party reaching out on your behalf, right? So maybe you're not hiring, you're having a third party do so. That's a non-solicitation is much more effective in that regard.
Thanks, Chris. We haven't touched on kind of what the courts call blue penciling and separability. How does that impact both non-competes and non-solicits, and how does it shape the way those should be drafted?
Yep. So what a blue pencil doctrine, or it's called a blue pencil doctrine, is it allows a court to reform the agreement if it's overly broad, overly inclusive, right? So court, let's say you have a non-solicitation, very easy example, for 3 years. Well, the max it's allowed in that state is 2 years. A court can go ahead and take a pencil to the agreement, make 3 years, 2 years, and then make it enforceable. That's why severability clauses are important when you're in blue pencil states. Is what it does is it basically says that it separates the unenforceable provisions from the enforceable provisions, and then for the unenforceable provisions, it says both parties agree that a court can go ahead and reform it to make it compliant, and that both parties agree to the judicial modification of that. Now, again, you have to know what state you're in, right? I know I said it many times, but for instance, South Carolina has a do not blue pencil law, right? So that contract, if it's overly broad, is going to fall on the face of its terms, right? So it's either going to pass or it's going to fail. If it fails, the court can do nothing about it. Your non-solicitation, your non-compete, what have you, is thrown out. They can't do anything about it for you. You're stuck with it. Whereas the other states, we're here in New Jersey, they do have a blue pencil doctrine where they would reform it. So when you're, again, we keep saying, draft it narrowly, know your state law, because you might not have that kind of like that backstop with a blue pencil doctrine that you may have in other states.
And I think that really, again, and I think we're just trying to emphasize how important this is. So it's why we keep kind of retreading on the same topics. But this ties back into what I was saying at the beginning, right? With access and acknowledgement and control as the key factors here. It all ties together, right? Who should have what information? Who has what information? Why do they have it, right? You design that correctly. Then you can design correctly where your non-competes should lie or not lie. And then you can design correctly your non-solicitations, right? Because, they should match up to who the person is, what information they have access to, what their job function is. So these things all interrelate. And when they're thought through properly, they can be incredibly effective. And you can take that deep breath knowing that they're not going to be overbroad, and they're not going to be struck, or they're not going to be blue penciled to such a point that they don't provide you any protection. So I think, that, bit of information that you just gave about blue penciling, or even worse, in the case of a state like South Carolina, that it's either pass fail, really is a good shift to let people remember it all goes to the design of the program and making sure that you spend your time designing it correctly. We talked about, Chris, and we got maybe 5 or 10 more minutes here. We talked about violations with respect to non-competes. What are the remedies if somebody violates a non-solicit?
So yeah, you can you can obviously go for an injunction, right? You're going to have to, which would restrain them from soliciting any further, right? And then they violate the court order, they're held in contempt by court, could possibly be thrown in jail. But that's just one aspect of it, right? They could then enforce it, they could not enforce it. Then you could also get damages too, right? So if they've gone out to your clients, they poached your clients, maybe it was $1 million in revenue stream, that's your damages. If you can quantify what your damages are, that's what your damages are due to that breach. And that once it gets past the injunction phase, which is the equitable phase, right? I'm going to stop you from doing X, Y, Z. You get to the damages phase, and damages is just like any other breach of contract, right? That's why it's important too, because a lot of times companies are going to consider, do I go after this person? Is it worth the attorney's fees? And honestly, most of the time it's not. I mean, you're going to spend tens of thousands of dollars to fight this if you really, really want to go after it. That's why having a fee shifting provision too, paying fees to the prevailing party, is so important, right? So if you win, you get all your attorney's fees back, if they had their money to pay it, from that former employee. So just, again, these little practice points to keep in mind when deciding what to enforce and what to put in your restrictive covenant agreements.
Thanks, Chris. I don't know if you have any other. I've got a couple practical business considerations that I always think about with respect to restrictive covenants. Maybe you can share, some that are always on the forefront of your mind when you're working with clients to put together the right type of policies and programs and covenants.
Yeah, most times. So clients will come to us, when they want to enforce it, or they're thinking about enforcing it. Right? We always suggest a demand letter first, sending a demand letter out to the former employee, copying their new employer, right? So why do you do that? A, it puts the employee on notice that if you don't stop what you're doing, we're going to come after you, or we may come after you. And B, it puts the new employer on notice too, that their employee, they're now the new employee, your former employee, is breaching a contract they had, or he or she had with you. And if they continue to allow that to happen, that new company can now be brought into the case for contractual interference. So now you're getting somebody in the case with deeper pockets, right? And typically, more often than that works. It gets at least gets the ball rolling, some kind of settlement. And there may not be a settlement. They could just go ahead and fire the person, which I've seen it happen just very recently. But you never ask for them to be fired, but if they get fired because they breached the contract, that's on the new employer. But when you're deciding do you take it that step further? Why are you taking a step further, right? Are you taking it a step further to make a point to your employees, or are you just doing it out of principle, right? If you're doing it as a practice point to make it to your other employees, where maybe you haven't enforced these in the past, and the hens are running wild, then yes, it makes all the sense in the world to go ahead and do that. But if you're just doing it on principle, somebody who's a low level, really is not taking any business from you, really probably wasn't the best employer, you're happy to see him or her gone, is it worth the cost, right? You're going to lose your time that you could have been investing in the business. You're going to lose money, or you're going to be investing money, because if you have that fee shifting in, the likelihood of you getting your fees, right? You can't get blood from a stone type deal. You have to keep that in mind when you're doing that. And also you have to look at enforceability, right? Where are you going to sue this person? Is it in a state that you're not familiar with? If you sue them in your home state, right? Is that judgment going to be enforced in their state? Probably not, because more than likely than not, their home state has a greater interest in protecting their rights. So you probably want to go to their home state. Are you going to get home cooked there? All things that we consider, we talk through when we're trying to decide how to approach whether to enforce a covenant or not.
And I'll pick up there, because again, I have like a different approach to that. Don't spend that time enforcing these claims, right? Take that time and spend it on putting together the right policies, procedures, and covenants, right? So that time spent enforcing, most of the time, as you said, is a waste of time. If folks would take that time and energy and spend more time really thinking about, again, those three: access, acknowledgement, and control, and really mapping out a plan that makes sense to protect these assets, the goodwill, the brand, and the employees and the talent, that's where the time is well spent. And this is time where you're meeting with your team leaders, right? You're meeting with, your professionals. This should be a group of folks who can really help you understand, what you're trying to accomplish, and how to best accomplish it in a comprehensive way. And it should reflect your culture, right? Many companies have different cultures, and the culture of the company should be reflected in how you draft these policies, how you enforce these policies, and just to bring it to a final conclusion, where I see it is on the reps and warranties and in the diligence in transactions, because what buyers are going to ask you, and these are the questions. I was looking at reps and warranties and schedules this morning on a transaction before I jumped on this webinar, and these were, I could tell you, were in there. One, okay, what are you doing to protect your brand? What are your policies and procedures and steps that you have in place to protect your brand? Two, what are you doing to protect your talent? What are your policies, your procedures, and the steps you have in place to protect your talent? And they're going to look at these policies, they're going to look at these agreements, and in the deal I'm working on right now, the buyer has a big concern that the covenants are overbroad and not enforceable, because these covenants were drafted, I believe, 12 years ago. The law in the states that these covenants will be enforced has shifted in the last 12 years. And the buyer is very concerned with two employees in particular, and whether or not the documents in place will protect the buyer if these employees leave. So this is the kind of the life cycle of this particular important aspect of your company, is that it helps you all across the cycle. It helps you attract your talent, it helps you maintain your talent and keep your talent all throughout your life cycle, and then it helps you get the best valuation for your company when you want to exit the industry. And so Chris said, waste of time to litigate. I agree, it's a waste of time to litigate. Spend your time putting together a real policy that has thought behind it, that is going to serve your company really well over a number of years, right up until the point where you want to exit the company. So with that, we've ran out of time. We've taken our allotted hour. Angie, I want to thank you and TechServe Alliance for giving us the opportunity to speak today. Chris, always a pleasure to present with you on a topic where we come at it from different approaches, but seem to get to the same perspective. So thank you for joining me. And Angie, I'll turn it back over to you now.
A big thank you to Marty and Chris, and thank you all for joining. We ask that you please fill out the survey upon exiting this webinar. Our next scheduled webinar will be Strategies and Tips for Effective Lead Generation on Tuesday, April 26th at 12:30 p.m. Eastern Standard Time. Please send any further questions to staff@techservealliance.org. Thank you and have a wonderful day.